Hi, I'm Catherine Ballantyne, a partner at Madgwicks Lawyers. Today's case update comes out of the Victorian Supreme Court and relates to caveat, something where we're often sought to give advice. The case is Burley Proprietary Limited and Soans and another, and it's 2021 VSC 236. This case relates to a property which was owned by a company. The company's director was Jonathan and his ex de facto partner, Monique. Now, Monique put on a caveat over the property for a resulting or constructive trust. Now, resulting or constructive trust essentially means that for some reason, the company holds this property either wholly or partially on trust for Monique. Now, this is often the reason for a caveat, but people often get it wrong, and the caveat is likely to be taken off either by the Registrar of Titles or by a court. If it's by a court, there are often significant cost consequences if you get it wrong, like in this case. Now, some of the reasons Monique put as to why she said she was entitled to have a caveat over the property in this case where she did some paintwork over the property for 1 to 2 days, or she helped Jonathan paint the property. This doesn't give rise to a caveatable interest. She'd been in a de facto relationship with Jonathan, and she lived at the property for a number of years. I think there was some debate as to how long she actually lived there. But once again, this doesn't give rise to a caveatable interest. She said she was owed money for doing waitress work at a restaurant from a related party to Jonathan, another company of which Jonathan was a director. Once again, that does not give rise to a caveatable interest over the property of this company. And probably the most convincing one, although it wasn't in this case, was that she said she had loaned Jonathan some money with a clause that said she was entitled to charge his assets, including putting a caveat on. Now, there was some debate as to what the terms were and what the effect was. Clearly, the property is owned by the company, so she would have had to have lent money to the company and had a charging clause with the company. Also, in this case, the evidence was that that loan had actually been paid back to her, so it wouldn't give rise to a caveatable interest. Now, the court was quite scathing and actually ordered against her indemnity costs, which means costs on a higher scale to normal. So it would have been 95 to 100% of Jonathan and the company's costs she had to pay. And the reason for this was that the court basically said she's put a caveat on. She's trying to hold up settlement. Jonathan had entered into a contract of sale with another party. She's trying to hold up settlement, and she has absolutely no basis for stating that she has a resulting or a constructive trust over the property, which is what she put for the caveat. So what are the lessons? The lessons are you need advice, legal advice, before you put a caveat on to make sure you have a caveatable interest. Often people come to us and say, this person owes me money, therefore I should be able to put a caveat on their house. In most instances, the answer is no, you can't. Secondly, she needed to phrase the caveat correctly. Even if she had a charging clause in some agreement that gave rise to a caveatable interest in the property, it didn't necessarily mean that the property was held on trust for her. So when she said she had a resulting or a constructive trust, this wasn't necessarily the right phrasing for the caveat and the right basis for the caveat. So you need to get it right, or it could easily be thrown out. And the third thing is if you do have an interest in a property, or you believe you have an interest in a property, get legal advice so that it is documented correctly, and so that therefore when you do, if you do have a caveatable interest, when you do lodge a caveat, that you actually have the documents to back it up. We advise frequently on caveats, and I encourage you to get legal advice if you're lodging one or if you're trying to remove one. I hope this was helpful. Thank you.